Welcome everyone to this Carson International Miller-Thomson presentation on customs issues. This session is on countervailing and anti-dumping duties, the Special Import Measures Act, and the process and tips and traps. My name is Dan Kisselback. I'm a partner with Miller-Thomson, managing partner in Vancouver, and leading the international trade and customs practice. On to the next slide, please. Our obligatory disclaimer that this is not legal advice, this is background information, and if you seek legal advice or other information, please contact a qualified professional. On to the next, Gus. Dave, introduce yourself perhaps today.
Yeah, good morning, people on the West Coast. Good afternoon, people on the East Coast. My name is Dave Pentland. I'm the Senior Vice President at Carson International. I've been involved in compliance issues as far as Canada Customs and U.S. Customs for closing in on about 40 years. And I'm always pleased to join Dan on riveting customs topics. Being a licensed customs geek, I enjoy these topics. Today's hopefully will bring some sense of how the process works on anti-dumping and countervailing duty. So glad to join you again.
Thanks, Dave. My background is about 32 years. I'm less seasoned than Dave in the legal area. I'm licensed in New York, Ontario, and BC, and we do inbound and outbound work. And so I'm delighted to be co-hosting with David today. Next slide, Gus, please. So countervailing and anti-dumping duties, we always like to have a little phrase that captures this. I find that the world is changing much faster than I can even bitch about it. That probably captures our situation here. Constantly changing with customs and international trade issues, right, David?
Yep.
So on to the next slide. I'll just wind into this presentation by saying the following, that this is all about unfair trade practices, the Special Import Measures Act, anti-dumping duty, countervailing duty. Countries have interests in protecting domestic industry, and there is a World Trade Organization design process that countries have generally adopted. It's considered unfair to dump goods, that is to export them or import them into a country below their normal costs at the home country or their value in the home country. And it's also considered to be unfair to subsidize goods in a particular manner and import them or have them subsidized in a particular manner and then export them to another country. So there's a complaints process that deals with this, and the CBSA and the CITT in Canada are the entities that are responsible for dealing with this. It really involves a contest between domestic industry and foreign producers. And so domestic industry often takes a position that certain types of goods are being imported and dumped or unfairly subsidized. There's unfair trade practices and they need to be protected against that. And the foreign producers take the position that no, that's not the case. So there is a complaint process which involves the determination of amongst other things, normal values, what's normal in the home country. It involves cost accounting and various number crunching processes that I won't bore you with in detail here. But this is something that most importers and producers should get legal advice on. It's not really a time for amateur hour because it can lead to a lot of adverse consequences. Your comments, David, on this?
Yeah, I would just say if you go to the next slide, it really is a way for domestic industry to appeal to the government that they like a level playing field, and often it's just not a matter of a simple matter of somebody in China manufacturing something cheaper than something's produced here. Quite often, foreign governments are involved because they're helping these manufacturers into marketplaces, and for that, they're able to lower the price that's lower than somebody in a domestic market can fairly compete with. So it's the emphasis is really on our government trying to protect domestic industry. So if you look at that, you can sort of understand the madness that goes into it. But it is fraught with, as like Dan said, you need to really dig into the weeds. And if your products are involved in this, you need to really understand it and don't just dabble in it. You need to get involved with it and seek professional advice from people. So,
Gus, if you could just go back to the beginning slide here. Anti-dumping duty is assessed when a good is sold in Canada at prices that are lower than comparable products in the country of export. Dumping occurs when goods are imported at a lower price than its normal value. That is the price that the good is sold in its home market, at a price below the total cost. And then on to the next slide, Gus. Countervailing duty is assessed when an exporter producer receives an unfair subsidy, and that might be like free electricity to produce or something like that from a government, allowing it to sell goods below Canadian market values. Subsidization, foreign governments may give incentives, grants, tax breaks, etc. to producers and manufacturers so they can export goods at reduced prices. And if it's determined that the imported goods are being dumped or subsidized, and it will or has or will cause injury to Canadian industry, anti-dumping and countervailing duty may be imposed. And so the general effect is to raise the price of goods to the value that they would have been expected to be had there been no unfair trade practice, had there been no dumping or no subsidization. Next slide, please. So here's an example or set of examples of the kinds of subject goods. We call them subject goods because they're subject to an order in the CITT, which describes the type of good. And that's important for reasons I'll identify later on. Here's some examples: aluminum extrusions, bicycles, carbon and alloy sheet, steel sheet, etc. So there's a whole host of different types of goods. Even including, I think, baby food at one point was a good that was subject to anti-dumping duties or provisional duties. So, ranging from whole potatoes to refined sugar and so on and so forth. So it's very important if you're in the business of importing goods or producing goods for export into Canada to keep an eye on what is the subject of either an investigation by the CBSA or a hearing or an order by the CITT, the Canadian International Trade Tribunal, because that an order or provisional duties could raise the cost of your imports dramatically. On to the next slide. So here's the wonderful process. It may look a little complicated for the uninitiated, but really there's two types of processes, and I'll turn to that in a minute. But the first part is the CBSA, the Canada Border Services Agency. They get a complaint. Canadian industry says there's unfair trade practices. We're being driven out of business. We can't compete, and we need protection from the Canadian government. Otherwise, we're going to run into real big trouble. The CBSA does the investigation. They go through the process. There may or may not be provisional duties that are imposed if there's a finding of dumping or subsidy. And then after that, there's a second process, generally speaking, that they overlap a little bit, but the CITT then considers whether or not it's actually injuring the domestic industry. So the first process is to determine whether or not there is a unfair trade practice. If the answer is yes, there's an imposition of provisional duties. And then off to the races you go in having the real debate about whether or not there's actual injury. And there's all sorts of wonderful evidence that's put forward in the court, the Canadian International Trade Tribunal, about this issue. And ultimately, there may or may not be a decision respecting injury. If there is an injury finding, then you get anti-dumping and countervailing duties. in respect of subject goods, goods that are the subject of the order. On to the next slide, please. 2 stages, as I mentioned. Stage 1, CVSA generally involves an investigation into the complaint respecting dumping or subsidization, and stage 2, CITT, economic inquiry as to whether or not the dumping or subsidizing is causing injury. Next slide. So the whole process takes about 260 days from the date when the CVSA receives a complaint. That may seem like a long time, but for the folks that are really getting involved in this, if there's a complaint and then an inquiry and all that jazz happens, there's a lot of information that has to be gathered. And as I mentioned, it's cost accounting. So you have to figure out what is the normal value in the home country, what is the level of subsidization, where does it come from, how does that enter into the cost of goods sold, and then do the calculations and complete questionnaires, get that information ready to go to the CVSA, respond to that information in a timely way, and then get a decision from the CVSA. And then if there is a decision, then you got to go on and do it again with this Canadian International Trade Tribunal on injury. So there's a lot of work to be done. And so one mistake that people make is that they don't deal with these things in a timely way, and it's hard to catch up. So the initial process is a complaint. Usually there's a lead complainer, some representative of the or complainant that leads the charge on this, and there is a groundswell of support by other Canadian producers, and they take the position that in these types of cases that they're being harmed by unfair trade practices. If the goods have likely been dumped or subsidized and are causing injury, the CVSA will investigate. There's some sort of prima facie case, some sort of on the surface case. They'll send requests for information, these questionnaires, to importers, exporters, and foreign governments to gather the required information. And then if the CVSA, as a result of gathering all this information, determines that there is dumping and subsidization, it issues a preliminary determination, and provisional duties are levied until the end of the investigation. So they can slap on duties on goods that are imported until the CITT decision is issued. And provisional duties are based upon the estimated margin of dumping or subsidizing. So it kind of brings up the cost of the goods to what the government thinks would be appropriate in the circumstances. On to the next slide. So if the CVSA determines that the margin of dumping or subsidy is insignificant, provisional duties are not imposed on the goods. The margin of dumping, if it's less than 2% of the export price and the subsidy is less than 1% of the export price, those are normally insignificant margins. Next slide, Gus. Importer of subject goods in the provisional period have an option. I mean, it's not a wonderful option, but you either, if you're going to import goods, you pay the determined amount of provisional duty, or you post security to cover the determined amount of provisional duty. And these bonds have to be issued in a form satisfactory to the minister, and there are bonding companies that do this type of work. Dave, you may have some experience with the bonding companies and all that.
Yeah, certainly. I mean, the bonding companies are normally brought in when companies decide that they would rather post security, but usually you're providing financials to surety company that says you're not going to walk away from your commitment, and those bonds be posted, and basically you're just you're accruing debt against that bond, and until such date as the anti-dump has been either increased or decreased. So that's the purpose of them. It's probably worth noting, I get asked quite a bit, can anybody complain to CVSA about anti-dumping? And the answer is yes. Anything in the tariff you can complain about, and the anti-dumping people get complaints continually from various segments of domestic manufacturers, and that's why the 260 days they use, because much of it they dismiss because it's just sour grapes that somebody is selling into the marketplace at a cheaper price because they can manufacture cheaper in a foreign country, and they actually have to dig through and determine which ones there's facts based, and so that's why the length of the delay. And I understand it from a broker's point of view, but it's often tough to explain to industry that all of a sudden there's provisional duties, and why did this happen to me type thing. So it's yeah, so I think that's the best thing you can do is, if you hear about it and it's a product that you import, get involved right away. Get involved in the beginning, and you have to get on board, and whatever the government's looking for, more information is better for them than less or ignoring things. So
yeah, we just recently had a case involving steel, and some Canadian producer complained about a Chinese producer, and the government, the CBSA, started an investigation. Representations were made in connection with that, and it was said that the complainant they didn't have complete information, that the complaint was internally inconsistent, and 101 reasons why the complaint was wrong, and the investigation was shut down. So that's where you want to be if you're a foreign producer or exporter of goods, is to get a line of attack on this thing right away. So a designated officer, not some ordinary officer, makes a determination of anti-dumping and countervailing duty payable based upon the person's understanding of what is covered by the order, what is a subject good, and whether or not the goods that are being imported are subject goods. So it's not just an ordinary tariff classification issue, it's a determination of whether goods are captured by the order. Where the CBSA terminates the investigation into the goods, or the CITT finds that dumping and subsidization has not occurred or is not threatening to cause material injury, provisional duty will be repaid. So you get your refund. Next slide, please. So the Canadian International Trade Tribunal, the CITT, has responsibility for determining the injury question. It will consider the impact of goods on prices, profitability, market share, and other things in determining whether or not the trade practices have injured Canadian industry. If it finds injury, then anti-dumping countervailing duties are payable on the imports after the decision, and they can be high rates. If it finds no injury, provisional duties collected after the preliminary determination are refunded, as mentioned before. Next slide. So the order of the CITT generally lasts 5 years. It expires after that period. And what happens invariably is that there's an expiry review process. So the CITT deals with the anti-dumping countervailing measures, reviews them to determine whether or not a continuation of the order is required to prevent continuing industry to domestic industry. The CITT's measures may continue longer than 5 years under multiple expiry reviews. So it's continued unless and until it's determined that the expiry of the measures will not result in the continuation or recurrence of dumping and subsidization, or that injury will not recur. So it's preventative. It's designed to prevent problems within the domestic industry going forward. Next slide, please. There may be a reinvestigation or a normal value review, and we've had a few of these where, the CBSA process is that, as I mentioned, is designed to keep normal values, export prices and amounts of subsidy up to date for enforcement of orders. Normal value is what the goods would be valued at, or their cost in the home country of origin. And in some situations, the government will do a reinvestigation or a review. These are proceedings basically on a paper process to establish values for new products, new models, or exporters who didn't participate in the normal value questionnaire processes and so forth. So interested persons can make representations respecting the need for a reinvestigation or normal value review to update values. And the onus is on that interested person to show the need for the updated values, changing domestic price, changing production costs, and so forth. On to the next slide, please, Gus. And what we've seen often is that sometimes exporters don't participate in the CBSA investigation at the outset. They miss getting the questionnaire respecting normal values, or they threw it in the round file cabinet and ignored it. And then later on, it's determined that this is not a good, this is a problem. And folks go cap in hand back to the government saying, we would like a review, please. And that's happened successfully. We've had a few situations I've mentioned here. Certain laminate flooring imported from China, the exporter didn't receive a questionnaire, received an adverse, the worst normal values, obtained permission to complete the questionnaire and got better values. Certain power transformers, again, the exporter ignored the CBSA questionnaire, the importer got tagged with anti-dumping countervailing duty, and we went back to the the producer and we got permission from the government to complete the questionnaire and we got better values. So there's a way of fixing this if you didn't participate in the process from the outset.
Yeah, Dan, I think it's worth pointing out that when Dan's talking about worst normal values, what in most anti-dump cases, exporters and importers who participate in the providing documentation to the government, they often end up with duty rates that are specific to that exporter. And that's because they prove certain values and that their values versus the normal values are in a range and they'll get a lower rate. Every other party that does not participate in that gets the worst normal value, and they'll pick the highest value, and that's, you get lumped in. So if you don't get involved, or your exporter does not get involved, or like Dan says, they put the notice into the round bucket in the corner, you get the worst value. And that's when they go cap in hand, like Dan was saying, and ask for the government to review it. Your exporter wants to provide information, and that's when you can get your own specific dumping duty rate to your exporter versus the worst normal values. So.
Thanks, Dave. Next slide, please, Dave, or Gus. Here's an example of why you want to be careful with what you're importing, and not just go off the tariff classification. You really got to understand what the order covers. Because if you are unclear about this, it can have a catastrophic impact on your business. In this case, we had an importer who sought guidance from a CBSA officer as to whether or not the goods were subject goods, and the goods in this case were aluminum products. There was an existing CITT order relevant to aluminum extrusions. So the officer stated that the goods didn't fall within these particular tariff classifications that would be considered subject goods. And the importer then proceeded to import huge volumes of the goods. Later, a designated officer found that the goods were subject goods and issued an anti-dumping countervailing duty assessment. And it was a huge assessment. The importer went back to the CBSA and said, hey, I thought I had some guidance, but he only got guidance in respect of the tariff classifications. It wasn't a statement that the goods were not subject goods. So, the importer made a mistake. He asked a particular question as to whether or not the goods were subject goods. He got a statement that indicated that the items didn't fall within the aluminum tariff classifications that would be considered subject goods. And ultimately, there was a disconnect, and a mistake was made and duty was assessed. And the importer ended up having to apply for remission of duties based upon officially induced error. So it's not the place you want to be. is the message. You want to make sure that you're getting the right advice, that if you're going to do something that is on the margins, and there's some question as to whether or not goods are going to actually be considered as falling within an order, it's nice to have advice or a ruling that deals squarely with that particular issue. Next slide, please. Here's a timeline example, gives you an idea how this stuff is dealt with. May 21, provisional duties are levied on upholstered domestic seating, UDS, from certain named countries. The investigation is commenced. The CVSA makes preliminary determinations under the SIMA that named countries have been dumping, and then the CITD issues a finding in September 2021. So it, for an ordinary litigator, this is light speed. This goes quickly, and there's a hell of a lot of work that goes into these things to get it in front of the tribunal. Next slide, please. Subject goods, in that case, UDS for domestic use, such as sofas, chairs, love seats, sofa beds. This is in the order. So there's a particular carefully laid out, described description of or list of goods. Covered goods included upholster seating that allows for movement, seating with metal and wood frames, seating produced in sectional items. So these are the things that are said to be unfairly subsidized and are harming domestic industry. So the tribunal very carefully sets out what's a subject good, and it doesn't necessarily follow a tariff classification. Next slide, please. The usual tariff classification numbers of the impacted imports are these. Next slide. However, the tariff classification numbers may apply to goods not included in the SIMA measures. So there may be some of these tariff classifications may reference goods that aren't covered, or they may be subject to change, or they may be the goods may be imported under tariff classification numbers not listed in the previous slide. So the underscored point here is that the application of anti-dumping countervailing duty is based upon the description of the goods in the order, in the CITT's order, not tariff classification. Don't get confused or bamboozled by that. So with respect to furniture, 2 provisional duties were applied since May 5, 2021, and we've listed them there. You can see provisional anti-dumping duty in the range for China of 206.36%, and provisional countervailing duty 89.54%. Total provisional duties almost 300%. Very punitive. It makes it difficult to make money this way, right? So if you're captured if your goods are captured by provisional duties, it could easily be a big problem if you continue to import and have to pay the duties at the end of the day. So what happens often is that folks just stop importing until this thing gets cleared up.
Yeah, and the difference between normal duties is about 9.5%. So something approaching 300%, like Dan says, pretty much stops anybody from importing. And I think, not to beat up on something like the brick, you probably find that Chinese upholstered furniture from the brick did not exist after this order came into place. So,
right. Puckers everything up. On to the next slide. Vendors who submitted questionnaires received different normal values and provisional duties. So as Dave was mentioning, if you are a good compliant person, you participate in the process and you get normal values, and provisional duties may be less, right? So you can see that there's quite a bit of difference between Violino furniture and Zhenjiang bow tie furniture, right? 20% versus 214%. So it's a good idea to participate in the process if you can. On to the next slide. So the takeaways, I should just stop to say this, that there are issues with respect to collections as well. And that importers may sometimes find themselves in a situation where they've imported goods and there's nothing they can do about it, that the goods have been determined to be subject goods and there's being determined to be material injury. And so they'll receive like a $45 million assessment or something like that. Then you have to deal with what is it that you're going to do with that? Are you going to pay? Are you going to try some other thing to deal with, mitigate against that assessment? And I should just mention that there is no director's liability provision within the Customs Act. There is under the Excise Tax Act for GST. And so there are things that we have done in the past that have dealt with the liability as a collections issue. I'll just leave it at that. And if folks have an issue, I think it's a good idea to seek legal counsel so that they can deal with collections and recovery issues. The government often will issue requirements to pay to the importers' customers, and there's different collection procedures that you can deal with, particularly with respect to anti-dumping and countervailing duty. So my takeaways, or our takeaways, are know which duties are subject to, or which goods are subject to anti-dumping and countervailing duties. And we've got a few websites here to kind of keep you informed, and consult with a customs broker or a trade lawyer to determine whether or not the goods are subject goods, and deal with anti-dumping and countervailing duty mitigation measures. Over to you, Dave.
Yeah, I think we've gotten to the end here, and I think just a word of caution is every broker subscribes to the email alert service for Anti-Dumping, Countervailing, and Import Measures Act. Certainly Dan's office does, because they specialize in customs issues. But if you as an importer are in that industry, you need to be aware of that. And it's worth its weight in gold. And the other takeaway from this is sometimes people get caught up in anti-dumping and countervailing duties because their products aren't correctly being classified at time of import. And that may be something that the government's looked at and has reassessed your goods, and all of a sudden they've decided that your goods are in a different classification, and that classification attracts anti-dumping and countervailing duties. And it more and more it crops up that it appears that some importers are aware of some anti-dumping, and the government's been aware of this and taken note, and they go looking for these cases. So what they'll do is they'll take a look at the known exporters and find out that they used to import upholstered furniture. All of a sudden it becomes wooden furniture, and it's coming in and somebody's classifying it like that. With technology these days, that's really a shortcut to a disaster just waiting to happen. So I would say if you're importing goods subject to anti-dumping, be aware of it, take it seriously, and certainly do not take any shortcuts on it. So that's my kind of words of wisdom as we wrap up. So
yeah, I just wanted to mention, folks, that our webinar coordinator Gus Gonzalez is going to be issuing providing a survey to get your input on future topics and what you find valuable and what is less valuable. So I would invite you to participate in that questionnaire process, get the survey, give us your input into the survey so that we can deliver more valuable content to you. So with that, I think we should end there, and I would like to wish everybody a good day, and look forward to seeing you again at our next event.